So well afternoon again, and welcome to the first webinar organized by the Chair for the Sustainable Development of the Metaverse of the University of Alicante. I am not Manuel DESANTES. He couldn't make it today for another commitment. So I will have the difficult task of replacing him as the moderator of this webinar. My name is Julián López, and I am Associate Professor of Civil Law at the University of Alicante. And today I have the privilege to be alongside a stellar group of panelists. This is the first of a series of webinars organized by the Chair for the Sustainable Development of the Metaverse, whose purpose is to assess whether the existing legal framework provides adequate protection to citizens as well as certainty to entrepreneurs in the Metaverse as to allow optimum use of the potential offered by this new virtual environment. To achieve that goal, the scientific committee of the chair has identified a series of action lines to be addressed in specific seminars. One, or in this case, two experts are commissioned to write a paper that will be presented and then commented by two discussants who will offer external insight to be considered by the authors of the paper. The webinars will be uploaded to the website of the chair, and so will the research papers after the subsequent revision following the comments made by the discussants and the audience. By the way, all of you are invited to make questions and comments using the chat to enrich the discussion between the speakers. The topic of this first webinar is the European Digital Act and the Metaverse fit for purpose, and we will discuss whether the current legal framework set by the European Union would fit the challenges of the Metaverse. Without further ado, I will introduce you the speakers. As I said before, we have today two speakers. Teresa Rodríguez de las Heras is an Associate Professor of Commercial Law at the University Carlos III de Madrid. Among many other things, she is also a member of the European Commission Expert Groups on Liability and New Technologies and the European Expert Group for the Observatory on Online Platform Economy. And we have also a second speaker. Aurelio LÓPEZ-TARRUELLA is an Associate Professor of Private International Law at the University of Alicante, and he has been consultant for the WIPO, the UIPO, the European Commission, and the European Parliament on intellectual property and digital law. So, Teresa, Aurelio, you have the floor.
Thank you very much, Julián. Thanks on behalf of Teresa and myself. Thanks very much the discussants that will be introduced later for accepting this invitation to read our draft paper and to provide comments on that. And thanks also to the attendees that in fact they will also help us to reflect on how to develop a responsible metaverse. Something that is not that's not going to happen tomorrow, like things like GPT is gonna happen in the near future. But in any case, we need to be prepared for that. Because of that, we consider that it was a good idea to start this series of webinars that we will be having on the different action lines that we have identified for this first year of the chair, with a, let's say, horizontal topic, which is the European Digital Acts that has been adopted or are still being negotiated by the European Commission, and how they will, whether they are fit for an adequate regulation of the metaverse. Teresa and I, we have prepared a common presentation. I will share it. I will start with a brief introduction of the, let's say, attributes of the metaverse and the main actors, and then I will pass the ball to Teresa to focus on the digital acts. We have one thing that we need to say in the very beginning is, I guess you are already watching the presentation, is what we understand by European Digital Acts. Certainly, with the use of the term act, the use of the term act has generalized on in the European institutions. So first thing that we want to make clear is that we are not covering all acts that might be related with the digital environment, but just to 4 of them, such as the Digital Markets Act, the Digital Services Act, and the 2 proposals about the AI Act and the Data Act. This does not mean that other topics or another regulation adopted by the European Union has no relevance for the metaverse, but they will be covered in other webinars that we are going to organize in the second semester of this year. And we were not the first on questioning about the application of these acts to the metaverse. In fact, the first reference that I found about this issue was a question by a member of the European Parliament from Italy that was asking the Commission whether they were going to launch a study about the regulation of the metaverse, and he could even ask the question of whether they were going to propose any regulatory act in order to cope or to tackle the challenges that she could identify, in particular with consumer protection. The answer by Mr. Thierry Breton was very easy. They said that they didn't have any intention to start any regulatory act, and he believed that the Digital Markets Act and the Digital Services Act provide an appropriate framework and the necessary tools to tackle issues concerning the metaverse. Well, actually, this is what we are going to be talking about in our study. But certainly, this was not the end of the question, because this was June 2022, and then in September, after the speech of the State of the Union by von der Leyen, in the program for 2023, it was included the metaverse for the first time. And now Thierry Breton, however, he has said what he said before, he changed his mind because of his boss, and he said, well, yes, we are going to study it. And basically in a post in LinkedIn, she underlined or highlighted the main principle that should, in his opinion, or probably in the Commission opinion, should guide the adoption of any regulatory measure about the metaverse. He said that people should feel as safe in the virtual world as they do in the real one. He used the term interoperable standard for the first time, and it will not be the last. He talked, very interestingly, he talked about the introduction of new payment system and new forms of identification of ownerships that already brings the idea of the use of blockchain technologies in this arena. And in the end, he talked about that all market players should contribute to public goods, coming to the debate of whether the big techs should contribute to the infrastructure and communication services in the European Union. A very different debate, but that is a hot topic as well. Well, after this post by Thierry Breton, we found the call for evidence that was launched by the European Commission in April to obtain opinions and comments about a non-legislative act, a communication that is planned to be published this summer, apparently, about virtual worlds, metaverses, and in this call for evidence, again, we found the same principles included in that were mentioned by Thierry Breton. First, it is mentioned that it has a strong internal market dimension due to the cross-border character of the services provided in these virtual worlds. It also used the terms open and interoperable. They also mentioned the risk of having a small number of big players becoming future gatekeepers, again, in terms that remind us of the discussion about digital platforms. And finally, they recall that the EU already has a strong regulatory framework that might be applicable to the metaverse. Certainly, we still don't have a definition of metaverse provided by the European Commission. We do have some definition on behalf of the services of the European Parliament and the Council, but certainly this is not a definitive definition. And in literature, in academic literature, when we look for a definition of the metaverse, it is usually a reference, Matthew Ball, the book of Matthew Ball of 2022, where it talks about an interoperable networks of real-time rendered 3D virtual worlds that can be experienced synchronously and persistently by an effectively unlimited number of users with an individual sense of presence. Well, from this definition that I believe it's a good starting point, but again, I think it's missing some important parts. From this definition, I said I identify 3 attributes that are essential in order to talk about the metaverse. The first one is immersiveness, in the sense that we are talking about virtual worlds, 3D virtual worlds, which makes a difference with what we have now with this Web 2.0, where we are just looking at websites. In virtual world, we should have a sense of presence in that virtual world, a sense of immersiveness. It is true that nowadays it is mentioned everywhere that actually virtual worlds can be accessed through different devices. We all have in mind the VR headsets of MetaQuest or the HoloLens, but we also have the possibility to access these metaverses that nowadays exist through PCs or even other devices. We are thinking about Roblox or Decentralized and the proto-metaverses that now exist. However, it is my opinion that in order to really talk about the metaverse, the immersive technologies are going to play a more and more important role in the near future. Roblox and other kind of proto-metaverses are now have a place. However, once the technologies evolve, we will see that new kind of metaverses will appear with further sense of immersiveness. A second important attribute is synchronicity and persistence. I would also like to refer to this as concurrency, in the fact that virtual worlds are experienced synchronously and persistently, in the fact that when we interact with people that is participating in those virtual worlds with their avatars, the actions that I make in that virtual world have immediately effects in other people that are at the same time enjoying or participating in that virtual world. And in fact, when I abandon those virtual worlds, when I quit the session, basically, those effects, the effects of my actions in those virtual worlds will persist. So the rest of the person that participates in the virtual worlds can still see them. It is important to mention that these virtual worlds can be accessed by an unlimited number of users. This is what Matthew Ball says, but actually nowadays it is almost impossible to obtain these results because of the limitation that exists in computing and also the limitation of the networks where the information is transmitted. But the idea of having an unlimited number of users is very relevant, because in the end of the day, these users are going to access from very different locations. And this creates problems in order to ensure law enforcement. And the final attribute, in my opinion, is interoperability. A lot have been said about interoperability, the possibility of different computing systems to communicate to each other and to read the information that has been created in another network. But in fact, even if Matthew Ball considered this as an essential attribute of the metaverse, we have to admit that interoperability does not exist yet. This is a desideratum for the future. We will see what happens. Matthew Ball is thinking on a metaverse where virtual worlds are compatible, in the sense that I will be able to use my avatar that has been created in a virtual world. I will be able to teletransport to another virtual world, bringing with me all the data, all my story, all the digital assets that I have bought. This is extremely difficult to achieve, but certainly it would be great to have that kind of metaverse. A final note about the attributes is that many scholars consider that blockchain is an essential attribute of the metaverse. People think that it is usually said that the metaverse will be decentralized or it will not be. Well, I do not agree. Actually, the metaverse that we now have looks more or less like this. It is composed of centralized platforms and decentralized platforms, but we can still call it a metaverse. Certainly, for many people, this is not the metaverse that we would like to have. We would like to have a metaverse that is interoperable, in the sense that we can visit as many virtual worlds as we want. But nowadays, it does not exist. But I do not consider that because it does not exist in a decentralized way, we do not have to talk about the metaverse. So, and this is an idea that that Teresa will come back to it, because it is quite relevant in the fact that we don't know how the metaverse is going to evolve in terms of business models. As you can see in this slide, there you can also see how the metaverse is organized. And in order to explain that, and I'm coming to an end, I think the best way to explain how the metaverse is organized is focusing on their main players. Those main players are the infrastructure providers, the platforms, the users, and the content and virtual worlds developers. Let me spend just 5 minutes in explaining each one of them, and then I will give the floor to Teresa to go in deep into the European Digital Acts. By infrastructure provider, I refer to the people that is building all the infrastructure that support the metaverse. And in my opinion, that infrastructure includes hardware and software. Hardware in terms of networks, cloud computing, device manufacturers. When I refer to device manufacturers, I'm referring, for instance, to manufacturers of AV devices that allow us to access to the metaverse. I'm also referring to software, the software that is used to build those virtual worlds. I'm thinking about companies like Epic or Unity Technologies that have created these game engines that are now occupying a central role in the development of the metaverse. I'm also thinking about AI tools that are going to use in order to automatically generate these the elements of these virtual worlds. Secondly, the second is platforms, and in platforms, certainly the most important one are interactive virtual worlds platforms. If I go back to the previous slide, in this case, platforms will be Roblox, will be Horizon Worlds, Decentralized, Sandbox. And as you can see, these platforms can be centralized or decentralized. But in any case, we are, even from this starting point, we see that they are platforms, and this means something in terms of the Digital Service Act and the Digital Markets Act. But another important aspect of this platform is that they are not just hosting virtual worlds, but they are also creating marketplaces where participants in those virtual worlds can buy and sell digital goods, among others. And besides this platform, these virtual worlds, I think we should also take into account that there are other platforms that play a role in the metaverse, but I would call platforms that provide ancillary services to virtual worlds. This is the case of NFTs marketplaces or payment platforms, which can be traditional payment platforms or can be platforms of cryptocurrencies. Okay. Two players of the metaverse, in my opinion, first are the developers. Under the term developer, we have to bear in mind that this is a huge category. Developers are the ones that are building the virtual worlds. And this can be companies like Nike, that, for instance, has its own virtual world in Roblox. But it is also media companies that are building or are creating experiences to be enjoyed in virtual worlds. That it is the case, for instance, of concerts that are held in Fortnite. And also we have advertisement companies that will work in couple with platforms in order to generate advertising in those virtual worlds. But at the same time, there are new players that are creating these virtual worlds and these contents, which are basically developers. They can be individuals that will use the tools provided by virtual worlds in order to create their own virtual worlds, but not only individuals. There might be SMEs that like to specialize in creating virtual worlds for others. And at the same time, these developers are going to create new tangible assets that might be exchanged in those marketplaces that I have mentioned before. If it is the opinion of the scholars in this field that this will create what is called the creators economy. And finally, we have users, which means us. We will participate in these virtual worlds using our avatars, our digital representation in the metaverse. Avatars that will be identified thanks to new mechanisms, like, for instance, decentralized digital identities, that it is sustained by many, that will allow us to use a single identity in all those virtual worlds using blockchain technologies. This is something that we surely need to be discussed in the future, and that we surely will cover in the chair. I pass now the floor to Teresa to explain the part of the digital acts. Please, Teresa.
Thank you, Aurelio. Thank you very much. Yes, let me please start sharing myself. So you should be exactly. So thank you very much, Aurelio. You have been indeed setting the scene that give me the opportunity to dive into our main question. And the main question is essentially to which extent this European Digital Act that we have considered relevant and that in this first step are applicable to the metaverse, and to which extent this potential application is going to enable a responsible development of the metaverses in the future. But as you can see, this starting point has a lot of legal and policy implications. Because if we assume that the metaverse or metaverses is indeed a world under construction, where the governance models are still undecided, the development strategies are not totally clear at the moment, they are emerging and coexisting business models, how can we really assess whether this world under construction is fitting into the model behind the European Union Digital Act? Because as you can see, on the one hand, we can assume, and this is definitely something that is not unrealistic, that the European Union Digital Act, even if they have not totally ignored the technological progress, including augmented realities, virtual realities, and immersive technologies, we can say that the metaverses related technologies are not explicitly, at least, contemplated in the Digital Act. But on the other hand, we have to bear in mind to which extent this interaction between the possibilities in the development and the evolution of the metaverses and the potential application of the Digital Act could in a way enable, so therefore the metaverse try to follow the enabling path of the Digital Act, or on the contrary, if this Digital Act is defining a model that is not considered appealing or is not considered attractive or productive by the metaverse players, in a way the metaverse players are going to depart. They are going to deviate from the model under the European Union Digital Act. So as you can see, behind this technical analysis, this exploration of the applicability of the Digital Act, there is a fundamental governance question. To which extent the metaverse is going to be built on the basis of the Digital Act model. So we have a universe of act and directive, but essentially act that we consider Digital Act in the context of Europe, and we are going to focus on the main protagonist of this second generation of the digital regulation in Europe, as Aurelio explained before, the DSA and the DMA. But behind the DSA and the DMA, the rationale behind precisely we are in need of a new regulation in order to update the Electronic Commerce Directive is precisely that the European regulator has realized what we have at the moment is not appreciating and acknowledging the real model that the digital economy has adopted today. And what is this model? What is the digital model that is behind? And the digital model that is behind is the platform economy. So if we come back to the description of the main players that Aurelio was explaining, and we focus on those actors that are considered the ones that are more distinctive, and in our opinion, the ones that are more distinctive are these interactive virtual world providers, so we call platforms, and how these platforms interact with users and content and virtual world developers. So if we focus on that part of the main players, what we have to ask is the question to which extent these players are the subject of the DSA of the DMA. So to which extent the DSA and the DMA material and personal scope apply to these main actors. And we focus on that because we believe that infrastructure providers, as Aurelio has described before, they are not really differing substantially from the kind of actors that we already have in the digital economy. So the fact that we need cloud computing companies, the fact that we need software provider in itself and from a legal point of view is not substantially different from the actors that we already have in the digital economy. So let's focus on these platforms that described how the metaverse is gaining a scale. As Aurelio has already mentioned, we have a coexistence of platforms that work as centralized platforms as well as others that are working or at least aspire to work as decentralized. But clearly, this slide shows something that is absolutely fundamental as a starting point. We do not have one single metaverse. We clearly have a plurality of providers. And that is the reason why we need to understand to which extent this plurality of providers is similar to the plurality of platforms that described this fundamental transition in the digital economy, from a digital economy to a platform economy. So our question is, if the DSA and the DMA are indeed trying to regulate platforms, because platforms are today not only the most important, the prominent players in the digital economy, but also raise fundamental challenges to the traditional digital service provider. Now the question is, are these platforms as well interactive virtual worlds providers? So what do we need to know? If we assume that there are some platforms in the metaverse that are centralized models, and this is absolutely fundamental because the DSA, despite the opinions of some scholars, is only and exclusively covering centralized models. So decentralized models are not properly embraced by the DSA, and indeed the logic of the DSA is the fact that there is an operator of the platform. Therefore, there is a central operator. We are only regulating centralized model. The second idea that is fundamental is the fact that these platforms, the platforms covered by the DSA, are contract-based organization. So it's absolutely key to understand to which extent the relationship between the platform and the users, indeed, the platform, in this case, the interactive virtual world provider, and the user, either the avatar, the user, individual user, or the content developer, for example, to which extent this contract indeed are equivalent to the traditional membership agreement that characterize any platform and is indeed properly regulated by the platform to business regulation in Europe, that is regulating indeed the platform to business user relationship. Together with this relationship, the one that I call it vertical, so the one that we conclude when we join a platform, and now when we create our avatar in a platform, the main purpose of a platform, Twitter, as the main purpose of a platform, Sandbox, Roblox, Horizon, is to interact with others, to live, to talk, to work, to attend meetings or to go to concert, to buy product or to sell and provide services. So what is absolutely fundamental is the number of relationships that are going to be concluded among the users of the metaverse. So as you can see here, this is the description, that the skeleton that I always use to visualize, to represent a platform. And that could be Airbnb, eBay, Amazon, Twitter, LinkedIn, on any other platform that you can imagine in the current platform economy. I can see that this represents as well, very well, at least to the extent that the platforms are going to follow a centralized model, how the metaverse could develop and evolve in the future. So we have an operator, in this case, the Horizon Worlds operator. Then we have users that opened, as you can see, an account by creating an avatar. Creating an avatar means joining a platform, concluding a contract, and by joining a platform, I'm saying something that is very important. I am joining a private jurisdiction. I am accepting the policies and the rules of the platform, as well as I am accepting to behave as is permitted in a particular virtual world, as I accept to use the possibilities that this virtual world offers to me. So this idea of platforms are private ordering or private jurisdiction or private legal system is extremely enticing. and very, very powerful, in my opinion, in our opinion, indeed, in order to see what is going to happen for the regulation of the metaverse in the future. So what can we say so far? To the extent that these kind of providers are following centralized contract-based models, we can see that interactive virtual worlds providers are indeed online intermediation service providers as per the platform to business regulation, and they are going to be covered by the DSA, in particular in relation to the provision under Chapter 3. Why? Because they have, or they may have, a transactional purpose. The idea of joining a particular metaverse is that I can't interact with others and probably, in most of the cases, provide a service or enjoy experience or probably buy a product. If that is the case, we will be under the same logic of the online intermediation service provider. What are the main issues in order to confirm this statement? The statement that virtual worlds providers are platforms, are online intermediation services provider. The main problem is what happens if they are decentralized models? The second question is, to which extent in all the cases we can find a transactional purpose? Please bear in mind the definition of platforms in the DSA and the definition of online intermediation service in the platform to business regulation. They refer to the fact that the users, in particular the business user, is joining the platform in order to provide or offer the provision of services and products to consumers. So there are transactional platforms for business to consumer relationship. The third element that Aurelio mentioned briefly as well is this idea of users that become creators, that become producers, and therefore this debate that we have already approached in the platform, in the sharing economy debate. We also have something similar in the case of the metaverse. The idea of consumer probably dilute and becomes less evident in the context of life-like environment, where people is really living there. It's not simply joining for a specific transaction. But definitely, the biggest problem here is the territorial scope of application. Because it's absolutely evident that the metaverse is not only defined by the factor of digitality that we already know and handle relatively well in the digital economy. There is a step forward. It's more than that. It's not purely digital. It's indeed reversing our perception of the digital economy. Let me explain. I personally believe that the metaverse is creating a new concept of spatiality. So we again have the feeling that we are in a world, in a place, that we are migrating to virtual spaces. There is location. There are locations, places, but virtual. So we need to figure out how to apply the concept of connecting factors that are in a way finding a new environment. No, we have indeed connecting factors, but they are not related to a geographical point. They are related to virtual point indeed. So about the problem of territoriality, we see 4 different options, 4 possibilities to deal with this problem. The first one is the fact that if we apply the DSA, as you may remember, Article 30 of the DSA is including the so-called traceability duty. That means that platforms operators need to request and collect certain information about the users, in particular the developers, right? The professional users. And among these items of information, they need to provide, for example, the address. So probably it's going to be very evident from the very beginning where is the real location of the developers. So as you can see, maybe we have a level of transparency that help us to solve this problem. The question is that a right path to take? Makes sense that we try to rely on a territorial connection that maybe are absolutely relevant for the purpose of this metaverse life and metaverse experience. The second possibility is to use the connector that the DSA used, this idea of substantial connection with the common market, with the union market. This substantial connection is related to the active users. So the scale, the scalability, the presence, the footprint of your metaverse in Europe. The next possibility that I like very much, despite the risk that this model raises, is the idea that these systems are going to work as self-regulated spaces, that they are going to create, as I have advocated for many years, private orders, private jurisdiction, and they are going to define the law of the metaverse. So you join this space, and this space is subject to a specific rules that are binding because you have indeed abide yourself by joining the metaverse and concluding the contract. That could be scary, I understand. That could be extremely controversial because they are private entities. But what if states, as the case of Singapore that we mentioned in our paper, in our draft paper, what if states start to gain presence in the metaverse, and therefore we can find a state-governed or a state-driven metaverses? If I join the European Union metaverse, I'm going to be subject to the European regulation. So we have still the possibility to think about other possibilities in terms of how the metaverse is going to evolve. What about the DMA? The DMA, as you know very well, is a complementary method for the antitrust law based on an ex-ante regulation or regulatory model. And the idea is to set out certain obligation to those companies that are considered gatekeepers. They are designated as gatekeepers. For example, the ones that you can see on the right side of the slide. In order to be designated as a gatekeeper, the DMA used the following concept: core platform service providers. Could our virtual worlds provider be considered core platform service providers? If we take a look of the metaverses that are more based or inclined towards socializing activities, so those who are essentially networking and interaction experience, I would say that it's going to be very easy to classify them as online social networking services. So they are in the list, I would say. They are in the list of core platform service providers, according to the DMA. For those platforms or metaverses that are more oriented towards the idea of transactions, I can again see very easy that they fit into the idea of online intermediation services. However, I hesitate a lot if we try to use other service providers' possibilities. For example, the idea that metaverses could be considered video sharing platforms. I don't think that the definition of video sharing platform describes properly the experiential, sensorial character of metaverses. So I don't think that that would be definitely the right definition. What happens if we apply the DSA? I'm going to conclude in 3-4 minutes, not more than that. But what happens if we confirmed that certain metaverses are going to be platforms, and therefore we are going to apply the DSA? If we apply the DSA, we start the application of this stacked on due diligence obligation that the DSA is based on. And in particular, we will apply this due diligence obligation related to content moderation, in particular, Article 16 to 18. The question is, do we need content moderation in the metaverse? Absolutely. Indeed, content moderation probably is going to play a fundamental, even higher fundamental role in the case of the metaverse. Why? Because precisely this idea that in the metaverse we expose ourselves to sensorial, experiential interaction, the possibility of being vulnerable, of being attacked, of being damaged and harmed, definitely increase. So content moderation seems to be fundamental. But what is the problem? The problem is that if we try to apply content moderation mechanism, all the common issues that we have in the common content moderation, assessment, definitely obtaining knowledge, defining illegality and compatibility is going to be as well in the metaverse, together with other challenges. And let me just conclude with these challenges before going to our main findings and work ahead. What are, in our opinion, the main challenges of applying content moderation in the metaverse? Content moderation, as it is at the moment, is essentially defined with a particular interaction model in mind. It's an interaction based on written statement, posts, and videos, essentially. I'm simplifying a lot, but essentially. What happened, however, in the metaverse? In the metaverse, we're going to have a lot of voice interactions. We're going to have situations that could be considered moderatable, so to be moderated, but they are essentially behaviors, actions, and in many cases, these actions are going to take place in a specific experiences. So the context and the perception is going to be fundamental in order to assess to which extent it is illegal or not that particular behavior or action. So detection and prevention is going to be difficult. Assessment is going to be even more complex because we need to contextualize how these particular people, how this particular avatar has felt offended in the context of this, as you can see, dialogue in the middle of the street. So as you can see, the sensorial and experiential element is going to impact a lot on the assessment of the content. The traceability, for me, that is fundamental. To which extent we can have content that is available to be reproduced back. So you told me in the metaverse, can I prove it? Can I really come back to what happened? Is that feasible from a technological point of view? If that is desirable from a privacy point of view? And what kind of measures the metaverse platforms are going to adopt? Because if I imagine situation that may take place in the metaverse, what I can see is that in many, many cases, removal or suspension is not going to be something very effective in the metaverse. Maybe we are going to start applying the kind of measures that we apply in the real life. Restraining measures, ostracism, invisibility of the avatars for others, spaces of control in order to avoid interaction between the victim and the wrongdoer. So in a way, we are going to implement preventive measures in order to avoid the perpetuation of the repetition of the particular illegal content. And even more, these kind of illegal activities are going to be only in the metaverse, or they are going to have impact outside as well. I'm going to be offended by this particular comment as well, and that immediately raised the point of the applicable law and the jurisdiction. So let me just conclude with a set of some conclusion, main findings, and open questions that we have already found. The TSA and the DMA apply to virtual worlds providers to the extent that they adopt a centralized model. So we don't know what is going to happen in the evolution of the metaverse ahead, and to which extent the providers are going to follow this centralized path, or they are going to deviate towards more decentralized metaverses. Can we assume that the self-regulated metaverses is a possible and advisable and desirable scenario? We can apply, certainly, the due diligence obligation by the DSA and the obligation of the DMA to this kind of providers, but bear in mind that these sensorial, immersive, experiential features of metaverses raise fundamental challenges, very, very substantial. What do we want to do in the future? What are we at the moment exploring? If we apply the DMA, do this kind of provision related to interoperability, as Aurelio mentioned before, and portability, for example, of the avatars or the experience of the virtual worlds from one metaverse to the other suffice? Is that sufficient? Is indeed fit for purpose? And finally, what do we want to do in the next step? We want to add to our analysis the AI Act. It would be ideal if we have adopted act in the near future, the AI Act and the Data Act and other related acts in order to really complete our analysis of the fit for purpose in the metaverse. Thank you very much. We've concluded here for the purpose of hearing your insight. Thank you so much.
Well, thank you very much, Aurelio. Thank you very much, Teresa, for this amazing presentation that just gives a hint of the written paper that you have already presented. And now we will give the floor to the discussants that we have today with us. It is an honor to present or to introduce you Christiana MARKOU, Associate Professor at the European University of Cyprus, practicing lawyer and member of the expert group of the Observatory on the Platform Economy. Christiana, you have the floor.
Thank you very much, Julian. Thank you very much, Aurelio and Teresa, for the interesting and very thorough presentation. And thank you all for attending this webinar, of course. I will spend the next 10 minutes commenting on the paper of the two colleagues that I had the pleasure to go through. And I will try not to exceed the time so as to give the floor to the next discussant and also the attendees. So in my opinion, the paper is an extremely valuable contribution. Why? It's because it comes before something actually becomes a reality fully, or it comes at its very, very early days, before we even know exactly what is going to be. And I consider this very important because it shows this kind of research can show the way and guide future research. So this is very important, and well done to both of you. I would say that one thing that I like about the paper, or perhaps I didn't like as a discussant, because it doesn't leave holes that we can exploit and raise issues, is that you manage to address possible objections. So before seeing the paper, I was thinking that, okay, but this metaverse, is it a new space? Is it really a whole new medium? Is it really the new wheel? So do we have totally new technologies? Do we have totally new applications of technologies? Totally new relationships? Totally new actors that we haven't met before? So the law should jump from its seat in a panic mode to regulate. And then when I saw the paper, I saw that you exactly addressed that point. And I like the fact that you accept that we don't know exactly how things will turn out, but for the time being, we see that these are information society services, more colorful, more excited, more wow, but still information society services. And this acceptance says a lot for the policy, because if it's that the case, at least for what we know now, it means that we need patches to existing regulation and not a totally new regulation. So going further, what I also think it's a strong strength of this paper is the section where you summarize all the possible other issues that arise in other areas of the law. I have to admit and say, of course, that it's a bit long, that section, though it's very useful and I enjoyed it and I will accept it. I think that it creates some, it makes the title of the paper at least a bit questionable, unless you can make it a bit more compact. But that section is so useful and reinforces what I said at the beginning, that it can show the way and guide further research, because it puts all the areas of the law and the various issues, and researchers can choose the one or the other that they want to focus and going further. Regarding privacy, I will just a quick comment on the GDPR and Article 9. Article 9 gives the definition of sensitive data and the lawful basis, but it's all other guarantees of the rest of the GDPR that the platforms will have to comply with. If you see that sentence, a very minor point. And also from that section is important also from another angle, and I don't know if you agree, but while I went through it, I was given the impression that many of the things that the law in many cases, it's there, and it's these businesses that are going to be the actors in the metaverse that will have to strive to comply with. And I thought that, okay, so the metaverse may be less the problem of law and more the problem of businesses. And then, as Teresa said, businesses, the big tech companies, may choose to deviate from that law. But then there should be the dilemma of the law, whether to insist and make them comply, because otherwise they will be violating the law. And that will be the choice if there are really risks and fundamental rights and interests that need protection, or if the law will say that I will change direction, the law should change a bit direction, not to hinder innovation. So that will be the dilemma, I think, and it comes out if somebody wants to read a bit deeper from that section. It's not just a brief summary of the issues, but it can say a lot more about this area. Also, private ordering. I should admit, Teresa, that the self-regulated model is indeed a bit scary. And DSA, as you highlight in the paper, follows this. It regulates the regulators. So it tries to regulate the regulation, the private regulation. With self-regulation, if we adopt that model, and we will still have the problem of territoriality if we want to continue regulating the way the private regulators regulate. Unless you suggest that we should not regulate the way they regulate and leave them totally alone, which is indeed a bit scary, and we will need other solutions to address the risks. About Article 30, I fully agree, and in many cases about the DSA and the DMA, I agree with your analysis, and I didn't expect to find any problems. Article 30, of course, only applies to, it doesn't apply to micro and small enterprises. So to the extent that those will be platforms as well, Article 30 won't give the solution that we should expect if we are going to focus on that. Finally, on content moderation, I like that section. It's very thought-provoking about the oral voice statements, just behaviors, and how we can moderate those. That is very interesting, and I think that that discussion should be informed by the question whether we want to do more online than we do offline. So offline, I can find you in the street, I can tell you something, and then you have the recourse that you have and nobody would, say what I said to you, and nobody has the expectation that my words to you will be saved and stored so that you can that they can be used by you. So that discussion and the dilemma of whether we want to do more online that we can do offline and we don't expect to do more offline will be helpful. And I will finish with just a question. I also found very thought-provoking your reference to the overflow effect, or overflow, or maybe I'm missing the exact phrase that you are using. I will find it. It's overflow. No, when things happening, overflowing yes. Impact. Yes. And it just made me wonder, will there be many cases you think that there will be no overflowing, in the sense that no matter how real the virtual worlds are, wouldn't still be real people behind those avatars that will be affected, perhaps not directly, but ultimately there will be some impact on a real person who is in real life and in the offline world. So I'm wondering whether you think there will be a lot of cases in which there will not be an overflowing impact. That's all, and thank you very much for inviting me to give this input, and congratulations for an excellent paper. Thank you.
Thank you very much, Christiana. Before giving the floor to the speakers to answer your queries and questions, I will give the floor to Jan KRÄMER, Chair Professor of Information System and Director of the DFG Research and Training Group on Digital Platform Ecosystems at the University of Passau in Germany. He's also the academic co-director at the Center on Regulation in Europe, and it is an honor to have you here. Jan, please, you have the floor.
Thank you all. The honor is on my side. And yes, thank you for giving me the opportunity to read and comment on this paper. As you've said, I'm not a professor of law, so I'm a professor of information systems. Yet I've been involved with the DMA for some time, so I will focus my comments on the DMA, also in the interest of time, and maybe also add a little technical angle to what has been said so far. Indeed, the DMA was not written with a metaverse in mind. It's stated in the paper, and I very much agree to that statement, but the paper argues, basically, in my reading, that the DMA might be quite flexible and also be able to accommodate the metaverse, and I also agree with that statement. So what I like a lot is that sort of the paper really, as Christiana also said, is ahead of time and sets the scene on what the metaverse is and how we can conceptualize it. There's a lot of people talking about it, and there's a lot of buzzwords flying around when you talk about the metaverse. So it's always very helpful to conceptualize it. You highlight 4 key ingredients, which I think is very useful, which is the immersiveness, interoperability, synchronicity, and persistence. And as such, the metaverse is simply put an immersive online world where participants have some identity that persists and whose actions also persist even when the participant is not online anymore. So with that conceptualization of the metaverse, I might add from a technical perspective that we could view the metaverse basically as an operating system. So that's something that's different to what's, so that's not explicitly being said in the paper. But in my view, it's really more like an operating system or an overlay network, because the metaverse will run for the time being on top of the existing internet. So the internet is basically the technical infrastructure that facilitates sending around bits and bytes, you know, over the networks. And on top of that, we have sort of another network, which is the internet, the metaverse, for which you also need potentially some special devices to access it, so VR goggles and so on. But in that sense, it's not so much different if you think about it from a mobile operating system, which also is tied to some hardware and smartphones, for example, that you need to access the internet with that particular operating system that runs on the smartphones, or that you can access with the smartphone, like an iOS, for example, or Android. So in order to use iOS or Android, you need a certain smartphone to access it. So in order to enter the metaverse, you need a certain device to use it. And they both rely then on the connectivity provided by the internet. So even the operating system relies on the connectivity of the internet. It runs on top of it, if you will, and you need special devices to access it. So it's very similar in that sense. So I think you could also conceptualize the metaverse, at least the infrastructure part of it, as an operating system. Right? So that would mean that those firms that provide access to the metaverse through devices or run sort of the infrastructure on which these interactive virtual worlds then can be hosted on, those would be operating system providers, potentially under the DMA. And so this is exactly what you've called infrastructure providers. Right? So those would be potentially running an operating system. On top of this infrastructure, then there are the platform providers, as you call them in the paper. And these are very similar, and this is also what Teresa has highlighted in her presentation. These are very similar to some of the platform providers that we already have. There might be online intermediation services, and depending on, there might be social network services, depending on the scope. I would even argue there could also be number-independent interpersonal communication services. Why not? If you have a space in which you can, the basic functionality is to communicate with one another, then there could be an interpersonal communication service, a number-independent interpersonal communication service. So there also the DMA is quite flexible because it knows several core platform services depending on what your scope is. And then there are business users and end users also, which you highlight in the paper as user groups, and also those are known to the DMA. And those business users, there can be merchants selling digital or physical items, there can be advertisers, or there can be developers. So looking at it in this way, the metaverse is not really that new. If you think about it, right? It's more an evolution than a revolution of a technical space, and also from a legal perspective, then I would argue. So where we can superimpose some of the concepts that we have, and also the concerns that we have, and why the DMA is in place and other regulations are in place, they might amplify in the metaverse, but they will not fundamentally change in nature, I would argue. So in some papers some parts of the paper say, that personal data, there will be more personal data being collected. And first I made a comment when I read the paper, said, why is there more personal data? But then because we already reveal a lot of personal data in the traditional, when we use Facebook and other types of services. But then you made a convincing argument that because it's so more immersive, and it could also, it could tap into our brains potentially in the future, and then there would be even more data that we leave unwillingly. So that's an argument I can see, but it's not fundamentally changing the nature of revelation of personal data as we're using a service, as we have on social media, for example, as well, right? I might not be even aware that I'm leaving these traces, and yet I'm leaving them. So accordingly, the DMA should still apply, and it should also be fit for purpose, mostly as I said, for the metaverse, classifying infrastructure providers as operating systems, these interactive virtual worlds, depending on their focus, as online intermediation services, social networking services, number-independent interpersonal communication services, And for that, also some interoperability requirements would apply, because operating systems, there are some requirements on vertical interoperability. There is, for number independent communication services, there's some obligations for horizontal interoperability. So the paper does not go through the individual obligations under the DMA and how they would then exactly apply one-to-one to a metaverse, and that could be a future project potentially. But it seems that as a first starting point, the DMA is really fit for purpose. And nevertheless, there can be open legal questions, I guess, that can be resolved under the existing framework. For example, you mentioned the right to data portability, which is under GDPR and also under Article 6.9 of the DMA. There is does it cover, for example, the right to port my avatar? It's not so clear, because it depends on, what information have I provided, or what information has sort of how was the avatar created? It might be that I took a collection of T-shirts, or a Nike shirt, or an Adidas shirt, or something like that, and then it will. I don't necessarily it's not just personal data. It might be conflicted with trademarks. It might be that some of the items have been provided by the provider, but they're not personal data in the narrow sense, just because I selected them for my. So there's some questions there on what is covered by data portability and what is not. So it's not so clear whether I can just take my avatar that I have created and port it somewhere else. But nevertheless, these are some, I guess, new interesting questions that come up. But I think they're manageable. So we don't need, I would also argue, we don't need a completely new legal framework. And it's flexible enough to accommodate whatever will become the metaverse. So I'll leave it at that. And thank you very much.
Thank you. Thank you very much, Jan. Well, I think there has been a lot of food for thought today. We have still some. We have still some time before ending this discussion. There are, if I am not wrong, I didn't see any question in the chat. I encourage everyone to ask questions or suggestions, but in the meanwhile, I don't know if the speakers have some thoughts to share after the comments. Aurelio, Teresa?
At least I do, but ladies first.
Oh.
Teresa.
Yes, okay, I start. Thank you, Aurelio. Thank you, Christiana, Jan. Thank you so much for your insightful comment, for your constructive comment. They are really indeed very rewarding, and provide us with a lot of guidance and an element that we can work on further, or we can refine in order to make more persuasive and convincing the argument. I'm going to focus in particular on the question that Christiana raised about this overflowing effect. And it's something that indeed I have hesitated a lot, and we will discuss with Aurelio as well, to which extent we can assume, or we can imagine that in the future we could face situations that are absolutely metaverse situation with absolutely no impact on the physical world. First, if that could happen, and second, to which extent we should assume and accept that situation, because if we accept that situation, that means that we are going to break off the allocation between the effect in the metaverse and the effect in the physical world. That means the allocation to a particular person, a particular user. So first, about the first problem, is that possible? I was trying to figure out situation. The first one is we create a trademark that is only existing in the metaverse, and this trademark is infringed. Could we consider that in this case, because the trademark has absolutely no equivalent in the physical world, there is no overflowing effect, in the sense that there is not going to be effect outside the contours, the perimeter of the metaverse? That could be one possibility. I will contradict myself in a minute. The second situation is, what happens if I do have a villa in the metaverse, purely virtual, and this villa is attacked and some material damages has been caused? The damages have taken place in the metaverse with absolutely, apparently, no impact on the physical world. And the third possibility is what happens if I create an avatar, and according to the particular metaverse, certain behaviors are forbidden, even if these behaviors are absolutely legal according to any jurisdiction, or in particular, according to the jurisdiction of the parties involved. So, for example, a very restrictive metaverse that say no kind of close relationship between avatar is permitted. So I have violated, according to the metaverse rules, the rules. I'm probably in a situation of illegal content or illegal activity according to the metaverse, but with no overflowing effect, because in the physical world, my behavior is absolutely legal. So these scenarios show that we could imagine a situation that are purely metaverse situation. The question is, if we believe that my villa in the virtual world is my state, so in my state, I have a real house, a real car, but also NFTs and also virtual goods. If something happened in my virtual good, indeed is affecting my property right as well. So in a way, we could always say that there is an indirect impact in my right, an indirect impact in my privacy environment, an indirect impact in, indeed, the one to whom we allocate effect. So I think, Christiana, that is a very good point, and I'm happy that you raise, because for me, it's not absolutely clear to which extent we want to accept that, or we should accept that something are purely in metaverse, no? And therefore there is absolutely no impact in the jurisdiction. Problems related to applicable law probably are also related to that.
Thank you, Teresa.
Thank you, Christiana. Jan, you have raised many questions. Probably Aurelio would like to, I'm sure that he would like to address them. Thank you.
Yes, in fact, more than addressing Jan's questions, I have other questions for him because I do agree with when you have mentioned the flexibility, but something that I was wondering when reading the paper to prepare the presentation was, but what about if we are playing with very strict requirements in order to identify gatekeepers? Nowadays, none of the providers or the companies that have their metaverse, they do not meet the requirements. So they actually do not need to comply with the obligation in the DMA. So would that flexibility also means that we should oblige new beginners of the metaverse to comply with the requirements, so that innovation is not blocked in future metaverses? I don't know if you get my question, but this is something.
Yeah, I'm not 100% sure, because Meta certainly is a gatekeeper under the DMA. So
yes, but
so that is at least one company that's being regulated. And then if you talk about these others, I don't know, Roblox or whatever, and
exactly. That's what I was thinking of.
Well, I mean, these are basically, and this is then the question, what is the metaverse and what is not the metaverse? I mean, as of today, they are basically games or platforms as they stand. And if they don't meet the thresholds of the DMA, it means they're not yet of a big significance.
Exactly.
But nevertheless, the DMA also knows the status of an emerging gatekeeper. So even though you don't meet the thresholds yet, but you're on the way to meeting them, you might yet be regulated under the DMA, especially with applications to data portability or interoperability. And then precisely because the DMA does not apply to smaller firms, it means that there is scope for innovation. Innovation is not hindered in any way, because they're not going to be regulated. And I also think that's necessary, because the DMA really puts heavy burden on the firms that are being regulated, and only big firms should be able to bear these burdens. So small firms should not be falling under the scope. Yet the platform to business regulation, of course, applies to all firms as it stands today. Right? So minimum requirements on transparency and dispute settlement and so on, they're required to any platform that is an online intermediation service, including, these roadblocks and so on. And by the way, I don't think it makes a difference whether the platform is centralized or decentralized for that, because ultimately it depends on whether you qualify as a platform, as an online intermediation service or not, and also under the DMA, ultimately, if you are a company behind it, right? If you're totally non-profit and don't make any money, you will not fall under the DMA, of course, right? You might fall under the platform to business. I'm not sure, because I don't think it's tied to any turnover. So a platform like Wikipedia or so on, right, it's not going to be regulated eventually.
This is another concern that at least I have about decentralized platforms. DAOs, a decentralized autonomous organization, for instance, decentralized is supposed to be a DAO. And my concerns is that I don't see how it is possible that they are going to comply with the obligation in the DSA. Take this as an example. First, look for the information about Decentraland that they are supposed to have in their website. It's impossible to find. There is supposed to be a foundation behind Decentraland. I don't know where they are located. But second, many of the participants in Decentraland will be professional users. Article 30 says that they have to identify themselves. But what about if in these DAOs, people is allowed to participate anonymously? I mean, these are concepts that are completely, we are not used to them, and I don't know how we are going to cope with this in the future. An advantage we have when we talk about the metaverse, and that probably they will be solved in the near future. We will find a solution, but I see there a problem for regulating the metaverse. I don't know your opinion about it.
Well, I mean, often decentralized is not as decentralized as you might think it is. There is still someone making decisions on what the decentralized infrastructure look like. Even in the DAOs, there's many different types of DAOs, including those, who has more rights to vote, who is allocating the rights to the people to vote, what's going to happen. Also in open source communities, decentralized, there is still a hierarchical, there's a structure, there's a consensus mechanism, there's a community, there's people that say more or less. So I think ultimately what's more relevant is who's making the money. And so is someone, as a company making money with this to an extent, then there is a certain company behind it, and then that's the angle of attack for the law. No matter what the consensus mechanism is. But I don't think we should be worried too much about these fully decentralized architectures. I think they exist, but I think personally it's very unlikely that they will dominate the world in the future.
If I may, Aurelio, add, because this point for me is absolutely fundamental. My initial approach is always that the DSA in particular is based on a very particular centralized model of platforms. Probably in the DMA, your argument could be definitely convincing in the sense that I can imagine allocating the obligation of the DMA, as you said, precisely, for example, on the one who has the control of the DAO or who can make profit in the more substantial part of that particular decentralized scheme. So I like that, and I think that could work. In the DSA, however, when you read the obligation can only be complied with by the operator of a platform that is centralized. So the model of Airbnb, the model of Amazon, the model of Twitter is difficult to imagine to try to extrapolate this kind of, let's say, content moderation obligation to a consensus-based mechanism that we have in a blockchain, naturally closed blockchain or permissioned blockchain. So that is probably the main distinction, in my opinion. I cannot imagine the effectiveness of the DSA if we do have a decentralized model. I don't know what you think about that, but definitely in the DSA, in my opinion, is not working so well. The distinction is more evident.
No, I agree, but I think my main argument is that I don't believe, so as of today, I don't believe that these fully decentralized architectures will become so dominant that they need to be regulated in that sense, because there is a strong centrality force in all of this happening from an economic perspective now, that even in DAOs, when you can sell your rights to vote, ultimately it will gravitate to a centralized model. I mean, because of the network effects and because of the organization, there are very, very strong forces that all of these, seemingly decentralized organizations will ultimately gravitate to becoming a more centralized one. And then the law is still applicable. So I don't think we should worry too much about these fully decentralized. There are sort of, for now, they're for nerds, they're for computer scientists, but they're not really in a state, and I also doubt they will ever be in a state where we have to worry about them from a gatekeeping perspective.
Well, thank you very much. I see that there were some questions in the chat. Some of them are already answered. But just a last question that, if I am not wrong, is an answer from Vasilis Katos. He asked, is the metaverse strictly virtual reality, or it is also augmented reality based? And will have this any implications? So this is from a definition of the metaverse. Is the metaverse strictly virtual reality, or also augmented reality based?
I tried to answer Vasilis in the chat, and I will share. I will share my answer with you and to see your opinion. I consider that AR is also part of the metaverse. Consider it as a phenomenon, as an evolution of the internet. It is true that it makes it more difficult to adopt a definition, because when we talk about virtual worlds, we are always basically talking about virtual reality. But we also have to focus on immersive technologies that either allow us to access virtual worlds as virtual reality, but there is another possibility, that is augmented reality, and those technologies has new challenges that we need to talk about. For instance, the privacy concerns, the collection of new categories of personal data. So it should be included in the phenomenon as such, but it really makes the phenomenon very difficult to define. For instance, if you go to the definition of Matthew Ball, AR is not mentioned. Augmented reality is not mentioned. He only talks about a network of virtual worlds. But in my opinion, that's incomplete, because you also have to include this perspective. This needs to be studied.
Well, thank you. There is some, Teresa?
Sorry, Julian. I think that is the reason why we need to produce or formulate a definition that is a functional definition. Try to avoid references to specific technologies, because indeed it is going to be future-proof. So we have to define metaverse in a way that is comprising a concept. So it has to be a concept that may be enabler or facilitated by technologies that apparently so far virtual realities, but immersive technologies. But let's see to which extent in the future we could add, indeed we will, other technologies. So I think that to the maximum extent possible, definition should be functional. So function-based, how this world functioned and what are the distinctive features completely regardless of the technologies that are used. As a general idea, no, for our work in this evolving reality.
If I may add something.
Yes.
Julian, I particularly like the confidence of Jan about how the DMA and the DSA are fit for purpose. And I think that I agree, because generally they are fit for purpose. And I ought to highlight, isn't it this beauty of EU law and more generally the general clauses and the technological neutrality that is a characteristic of all these legal provisions that allow the law to be so flexible and to catch situations and services that were not contemplated at the time that the law was created. For example, if you think the Unfair Commercial Practices Directive and that general clause, nothing can escape a commercial practice, no matter how advanced. That general clause in the Unfair Commercial Practices Directive can catch everything. If we think about the Distance Selling Directive, Teresa, of the 1997, it came at the time when online stores did not exist, but till 2014, it was regulating distance selling on the internet. So I think that the DMA and the DSA, because they don't name a technology and they don't seek to regulate any technology by a name, they have this neutrality that gives them the flexibility to respond to new challenges, even if they are not specifically contemplated.
I'm not sure I agree to that, actually. I mean, you said, yes, I had confidence that it was flexible, and actually, to my surprise, it is like that. I think it's more a coincidence than sort of a deliberate action, because the DMA actually is not meant to be super flexible. It's meant to be a relatively stiff, targeted law. It's not like a general competition law, right, where you have a general clause and then you can everything falls under it. It's very specific by purpose, so there is less argumentation about it, there's less litigation about it, and you can effectively enforce. And maybe it's more because I view the metaverse less, as I said, as a revolution, more like an evolution of the services that we have. That's why it's fit. And sometimes regulators get lucky and have sort of a regulation that shows to be very future-proof. But more than often, regulation is also not future-proof. If you look at the database directive, for example, I think we have come to realize that it's not a good thing to have. And so I think it's more luck, in this sense, or the nature of the metaverse being evolution than a deliberate action.
Yeah, they don't always get it wrong. Get it right. I agree with you, but in many cases, with this generality, they are just in.
Well, thank you very much. I am very sorry to have the task to close this fruitful debate, but I promise to stick to the schedule and finish at 6 p.m. So it's time to close, to wrap up this amazing panel. But before that, let me just announce the next webinar of the chair that will be on Monday, June 26th at 4:30 p.m. again. And the topic will be the protection of digital identities in the metaverse. Martin Evers, president of the Robotics and Artificial Intelligence Law and Society and professor of IT Law at the University of Tartu, will present the preliminary conclusions of a paper on this topic. I invite you all of you to attend this second webinar. Thank you very much. Thank you very much to all the speakers today and the public for being here. And that's all for today.
Thanks a lot. Bye-bye.
Thank you very much. Bye-bye.
Bye-bye.
Thank you.